It's my pleasure to introduce and welcome Professor Foley. I'm going to go over her bio to give you an idea as to how lucky you are to hear from such a scholar. Professor Foley has her BA from Emory University, her law degree from the University of Tennessee College of Law, and the LLM from Harvard Law School. Professor Foley is a founding member of the FIU College of Law. She teaches constitutional law, civil procedure, and healthcare law. Professor Foley is the author of Liberty for All, Reclaiming Individual Privacy in a New Era of Public Morality, Yale University Press, 2006. The Law on Life and Death, Harvard University, 2011. And The Tea Party, Three Principles, Cambridge University Press, 2012. She is a frequent media commentator and op-ed writer. Her opinions have been aired by the Wall Street Journal, Fox News, New York Times, Washington Post, Miami Herald, National Law Journal, National Public Radio, SCOTUSblog.com, Jurist, CNN, and the BBC. Her writings on constitutional and healthcare law have been published by the Harvard Journal of Law and Technology, Arizona Law Review, George Mason Law Review, Tennessee Law Review, Syracuse Law Review, Food and Drug Law Journal, Albany Law Review, Wayne Law Review, and the Encyclopedia of the Supreme Court, among others. Professor Foley presently serves on the editorial board of the Cato Supreme Court Review, an annual publication of the Cato Institute in which the leading legal scholars analyze the most important cases of the Supreme Court's most recent term. It's my pleasure to welcome Professor Elizabeth Price Foley.
Okay, so you can see that actually Marshall thankfully kind of, I told him to sex it up a little, make it a little sexier, because my title was something boring like, you know, NSA surveillance, is it constitutional? So thank him for the better title. But, you know, you can see the idea. I just wanted to talk to you a little bit about this topic of National Surveillance Agency surveillance and what they're doing and whether or not it's constitutional. Now, the one thing I don't want to do, because I've given this kind of talk before, is I don't want to just sort of add to the hyperbole that surrounds this issue. I think passions sort of run high on this, and a lot of times those passions are based more upon people's sort of gut instincts about preservation of their privacy rather than you know, sort of a calm, cool legal analysis of it. And so I'll just preview ahead of time sort of how I feel about it, so you'll have my bias sort of going in. Because I think anytime you teach anything, you kind of owe it to the audience for them to know your perspective so that they can challenge you to and just take it with a grain of salt. Okay? So my perspective here is that I'm not a big fan of particularly Section 215 of not a big fan, as I was saying, of Section 215 of the Patriot Act. It's the portion, I think, that's the most controversial. It's where the NSA is collecting what's called metadata. And just quick definition of metadata. I'm sure you hear about metadata all the time in the news, and it's not often explained very well. It is data about data. It's not content. It's not the content of your cell phone communications or not listening into your calls. It's not the content of any emails. They used to do metadata collection of emails. They're not doing that anymore. It is literally a list of phone numbers dialed, incoming, outgoing numbers from a certain cell phone, the duration of those calls, and some people think it may also include sort of locational data, GPS data. So far, the NSA is denying that that's true. But at a minimum, it's just a list of phone numbers called and the duration of those calls. Okay, so that's the part that I am not crazy about. I'm not crazy about it, not necessarily because as a constitutional lawyer I think it's unconstitutional. I think that's a very close call, as you're going to see. And the one thing I don't like to do as a constitutional lawyer is condemn something as unconstitutional just because I don't like it. Right? I think that's a bad road to go down as a constitutional lawyer. So I'm resisting that. I do think that Congress is going to toy with the Patriot Act and probably change Section 215, maybe get rid of it altogether. There's a lot of momentum for that. I would be in support of that. But the question about whether or not it's constitutional, I think, is a much, much closer call. And then there's Section 702 of FISA. I'm actually not going to spend a lot of time talking to you about 702 because I think it's relatively uncontroversial, and there are no serious constitutional questions being raised about 702. The reason for that, even though it is the content of communications, is because Section 702 of FISA is spying on foreigners, right? And if you think about it, we've done that for a long, long time. We do it, every other country in the world does it, and if we don't do it, we put ourselves at a severe disadvantage. So I think that's why most people recognize that either under the President's Article 2 powers or Congressional Article 3 powers, there's plenty of constitutional power to spy on foreign countries, including allies, by the way, which we've also done historically for many years. Click. All right, so I'm going to focus on Section 215 metadata. I've given you the long statutory language just so you can see the seed from whence all of this has sprung, okay? It's often referred to as the business records provision of the Patriot Act. And what it does is it gives the FBI the ability to produce, to go to FISC. FISC is the Foreign Intelligence Surveillance Court. It's that special, spy court or whatever, the NSA court. Go to FISC and ask for production of any tangible things. Any tangible things. It's not just cell phone records that they could be collecting under Section 215. I rather suspect it's a lot broader than that. And at one point, we'll probably find out about that as Edward Snowden keeps releasing portions of his stockpile of information that he took with him. But it includes any tangible things. So books, your library records, any papers, any documents, any other items. And so what they're getting here under 215 that we know about is cell phone records being kept by your cell phone providers. And they can ask for it for an investigation to obtain foreign intelligence information not concerning a U.S. person or to protect against international terrorism. So basically they can use Section 215 Business Records Authority under the Patriot Act to ask for any tangible record that relates to protection against international terrorism. That's pretty broad, right? That is broad statutory language. Right? I want you to feel how broad that is. And what it's been interpreted as by FISC is not only can they get the cell phone records of the bad guys, the guys who are on the known terrorist list of the NSA, but they can get cell phone records of anyone within 3 hops of that seed list, the terror list. So if there's a terrorist and the terrorist calls one person, that's 1 hop. That person calls another person, that's 2 hops, and that person calls a third person. You see how far out that goes, that 3-hop policy that's been approved by FISC? And that has led to speculation that it covers virtually every cell phone record in the United States because you just do the math out of the seed list and you get millions and millions and millions of people. Now, the one thing that the Obama administration has just done unilaterally through executive order changes is narrowed the scope of 215 collection to 2 hops. So that's going to cut down somewhat on it, but it doesn't entirely solve all the privacy problems, obviously, that people are concerned about. Okay. So here's the other part of the statute that I think is interesting. In order to get approval under the statute to get all these records, they've got to show certain things to FISC. What do they have to show? They have to show that there are reasonable grounds to believe that the tangible things sought are relevant to an authorized investigation, and they are presumptively relevant if, and then I've highlighted little 3I there, if it's an individual in contact with or known to a suspected agent of a foreign power who's the subject of such authorized investigation. That's how they get the authority to do the hops, right? Because you're somebody who's in contact with a suspected terrorist and it is relevant to their investigation, and you can see the statute even goes further. It says it's presumptively relevant. So there's really only so much under this statutory rubric that FISC can do. People criticize FISC to say, well, they rubber stamp every time NSA goes and asks for something under Section 215, it's granted. I think the statistic is something like 98% of the requests for 215 documents have been approved by FISC. Well, you can see that there's not a lot of wiggle room in this statute for FISC to disapprove their requests because of this presumptive relevance language. Okay, next question, right? Okay, we know what the statute says. We know the statute is breathtakingly broad, and this is something, you know, our representatives in Congress have blessed. But there's the Constitution, right, our supreme law of the land. You've seen this language, I'm sure, before. The Fourth Amendment gives us the right to be secure in our persons, houses, papers, and effects against unreasonable searches and seizures. And then it's got this other clause, the warrant clause. It says that no warrant shall issue except upon probable cause. Now, a lot of people think, who haven't gone to law school, that the Fourth Amendment means that you always have to have a warrant to conduct a search or seizure. Not so, at least according to a couple hundred years of Supreme Court interpretation of the Fourth Amendment. The Fourth Amendment does not always require a warrant. In fact, oftentimes in shocking situations, the Supreme Court has said it does not. And I'm going to talk to you about those situations in just a second. So the key language, according to the U.S. Supreme Court for a long time, is not the warrant clause, but the preceding clause about reasonableness. The lodestar, in other words, of the Fourth Amendment is this reasonableness language, and that's what the courts generally focus on. The one thing we do know about the Fourth Amendment was designed to prohibit what's called general warrants, which was what the King of England did, right? When they would basically get a warrant from one of the king's bench, from one of the king's own judges, to go out and just kind of rummage through your house and see if they could find some evidence of illegal activity. They're not allowed to do that, and that much is clear in terms of original meaning of the Fourth Amendment. And we'll ask ourselves whether that's what the NSA is doing under Section 215. One of the questions we're also going to ask ourselves is collection of metadata even a search? Right? Because that's a question that there's a lot of disagreement about. So we'll go through that in just a second. And even if it is a search, we still would have to figure out whether or not it was a reasonable or unreasonable search in order to assess the constitutionality of it. Okay, so a couple big Supreme Court cases I want to talk to you about. First, Terry versus Ohio, 1968, height of the Warren Court. Okay? And what we had was the majority of the court saying that that a stop and frisk does not violate the Fourth Amendment, and it doesn't require a warrant. Because what is a stop and frisk, after all? Stop and frisk is when a cop is sitting, you know, in his car eating a donut, or he's hanging out on the corner, and he's watching people. And maybe he's in a part of town known for certain types of illegal activity, and he's watching and he's waiting, he's seeing what's going on. And all of a sudden, somebody catches his eye. Maybe he's arrested him before, or maybe he's doing something suspicious. And he says, I'm going to sit here and watch that guy. And he watches. And he says, he's about to do something illegal. I can smell it. I can feel it. I'm an experienced cop. I've been doing this for a while. He's casing that joint. He's about to rob it. Or he's about to do a drug deal. I can smell it. Right? I think he might have a weapon, too. So what the cop does at that point is he goes up and he says, hey, what are you doing? And the guy says, nothing, right? He says, I'm just going to pat you down, right? And then they start doing that thing, and they find stuff in pockets, guns, drugs, whatever. And they're doing all of this without a warrant. There's no going to the judge first to see if they can pat him down. They're just doing it right there on the scene for purposes of policing the neighborhood. And the Supreme Court said this is perfectly fine. This is indeed a search. It is indeed a seizure, because when the cop stops you, you don't feel free to leave, right? He's got you right there. So it's a search and it's a seizure, but it's a reasonable search and seizure. And even though it doesn't have a warrant, it's perfectly okay, as long as the cop has what's called reasonable suspicion to believe that you are about to engage or are engaging in criminal activity. They can do the stop and frisk. The interesting thing about this is it's not just the cop on the beat who's doing this to keep the neighborhood safe, but they've extended it to things like border checks. They've extended it to traffic stops, most notably sobriety checkpoints. Have you ever seen the cops out there on a Friday night? They got the whole road closed down, and they're just stopping every third person or whatever, say, hey, have you been drinking tonight, kind of thing. They're doing all of that without a warrant. Right? And it can be pretty intrusive of your privacy. It certainly could constitute a search. It certainly is a seizure, and yet it's done without a warrant. Even worse, in my opinion, there's a Supreme Court case involving random drug testing, where basically they can take the Terry stop and frisk idea and say, look, if you are a person who is an employee in a high-risk position, and in particular, the Supreme Court case involved people who I think they were conductors on railroads. You don't want your conductor on a railroad being drunk, you know, just like you don't want your pilot being drunk, right? People who are in certain sensitive positions where if they're impaired, it can imperil the life of everyone around them. Those people can be given random drug tests with no warrant, obviously extremely invasive of your privacy. I don't know about you, but if you have to pee in a cup, I consider that to be pretty invasive of my privacy. And all that can be done without a warrant, and it's perfectly consistent with the Fourth Amendment. All of that is because of Terry versus Ohio. Okay. So we'll talk about that in relation to NSA in just a second. Second case, Smith versus Maryland, 1979. Supreme Court deals with a guy, Mr. Smith, who is under investigation by local Maryland police for, they think he's been making harassing phone calls of a woman. And they're pretty sure it's him, so they basically go to the phone company, the local landline company, and they say, hey, we want a pen register placed on Mr. Smith's landline. Now, I don't know if you know what a pen register is. It's a pretty obscure little device, but it's just a little device that the phone company puts somehow, on their equipment. And it monitors the ingoing and outgoing phone numbers dialed from a particular phone. So they put this pen register on Mr. Smith's landline, and they do it again without a warrant. And the Supreme Court was asked whether that was consistent with the Fourth Amendment. The Supreme Court said, yes, it is consistent with the Fourth Amendment because it's not even a search. And you say, well, how could it not be a search? They're putting it on your landline and figuring out all the phone numbers you dialed and all the phone numbers that were dialed to you. How can it not even be a search? Well, the Supreme Court came up with this thing called the third-party doctrine. And what it was is they said, you have absolutely no reasonable expectation of privacy on these incoming and outgoing phone numbers dialed because you know that some third party, the phone company, knows about all your activity. In other words, you're voluntarily turning over this information into the hands of a third party, right? They know about it. So you can imagine that Smith versus Maryland makes what the NSA is doing very interesting from a constitutional perspective. Okay, we can switch here. You're my clicker. Okay. All right, here's some interesting language from Smith versus Maryland explaining this third-party doctrine. All telephone users realize they must convey phone numbers to the telephone company, since it's through the telephone company switching equipment that their calls are being completed. All subscribers realize, moreover, that the phone company has facilities for making permanent records of the numbers they dial, for they see a list of their long-distance toll calls on their monthly bills. This court has consistently held that a person has no legitimate expectation of privacy in information he voluntarily turns over to third parties. And in fact, they've further taken the position that once you turn over your information to a third party, a bank, a cell phone company, a hospital for your medical records, that it's not even your stuff anymore. It's not your person, houses, papers, or effects, in other words, within the meaning of the Fourth Amendment. It's just not yours. It belongs to the third party. So you don't even have a property interest in it any longer. Now, so you say, well, you can immediately see that Smith versus Maryland and the Terry stop and frisk are going to be used vigorously by the government to support the constitutionality of Section 215 if and when it comes before the Supreme Court. But, there are some differences that at least one lower federal court has noticed. For example, Smith, the pen register case, it's one guy who's suspected of a crime. They already believe he's, engaging in those harassing phone calls of a woman, and then they put the pen register on the line, and then it ends up being constitutional in the eyes of the Supreme Court. Compare and contrast that to Section 215, where you've got millions and millions of Americans are innocent. Nobody is suspecting them of any crime. They just happen to be 2 or 3 hops out of a terrorist seed list. And their phone calls are basically getting collected the same way the pen register collected the information on Mr. Smith. So the question is this a difference that matters? Is it a difference that should matter to the courts? Or does the third-party doctrine apply regardless? Because if you think about the rationale of the third-party doctrine, the whole idea is, well, you've turned it over to a third party, so it's not yours anymore, so go away. There is no Fourth Amendment problem. If that's really what's going on, then that difference between one person suspected of a crime versus millions of people having the same data collected shouldn't matter to the court. And again, are they even your papers or effects at all? Another question, is Section 215 metadata analogous to a Terry stop and frisk? Right? Is it sort of the same reasonable behavior where they think you have some connection to criminal activity and they're effectively just kind of in a computer way stopping and frisking your metadata and not tapping into the content of your communications? And so, again, the statute says, that's the statutory language again, there has to be reasonable grounds to believe that the tangible things sought are relevant to an authorized investigation. If you parse that statutory language very carefully, it seems to almost mimic the Terry standard from that particular case. And I'm sure that Congress was cognizant of Terry at the time it wrote Section 215 and was probably doing its best to make sure that the statute was constitutional. Okay, a couple lower court decisions that you should just be aware of. One case came out one way, the other case came out the other way. The one that got the most attention was this one from Judge Leon in the federal trial court in the District of Columbia, the Clayman versus Obama case. And you can see both of these were within a couple weeks of each other at the end of last year. And what he did, Judge Leon did in Clayman, was he granted a preliminary injunction. He said essentially that I believe Mr. Clayman, who's the plaintiff in that case, who was challenging the constitutionality of Section 215, has demonstrated a likelihood of success on the merits of his underlying Fourth Amendment claim. He hasn't ruled on the merits of the Fourth Amendment claim. That has not yet happened. But he granted a preliminary injunction to stop NSA from continuing with Section 215 because he thinks ultimately Clayman is going to prove his Fourth Amendment violation claim. And in getting to that conclusion, Judge Leon basically looked at Smith, which is the big case staring at us in the face, right, and said, I think Smith is inapplicable. Just completely inapplicable. So I'm not even going to consider Smith because Smith involved what Judge Leon called short-term, forward-looking searches, right? That pen register. Short-term, it was actually only a few days that it was on Mr. Smith's landline. Forward-looking search. Whereas 215, said Judge Leon, is long-term, back up to 5 years retrospective, and obviously going backwards rather than forward. So he said it's more invasive of privacy. It's more like a recent case, he said, called U.S. versus Jones, where the Supreme Court in 2012 said that you can't put a GPS tracker on someone's car. And this court was completely split as to why you can't put a GPS tracker on somebody's car, but we had a majority conclude that you can't put a GPS tracker on the car. And basically it's because, you know, the question was, if the cops can sit there and watch your movement in a car, or follow you, tail you, right, in their trooper car, all day long, then why would it not be equally constitutional for them to put a GPS tracker on your car? It just makes it easier for them to follow you around all day. And the Supreme Court said, yeah, but it does make it easier for them to follow you around all day. And in fact, it makes it more likely that they're going to follow you around all day, and they're going to see every move you make rather than just a couple hours of your day. And therefore, it's unconstitutional. The problem with the Jones case, again, is that we don't have a clear analytical framework for why it's unconstitutional, but we know it's unconstitutional. Anyway, Judge Leon said, this is more like that. This is more like a GPS tracker. And he also said, look, you know, phones and technology are evolving. You know, back when Smith versus Maryland was decided in 1979, you know, it was a landline. And we just looked at phones differently. Now we've got a phone in our pocket all the time. I usually have mine in my pocket, but it's right there. It's only within 10 feet of me at all times, even when I sleep, right? And you're probably the same way. It's almost like it's built into your body at this point. Probably in 10 years it will be, right? So it's more invasive of privacy just because of the way that we use phones now. He also said, look, I'm not even convinced as a judge that 215's ever done anything of value. You probably read about that in the media, right? There's a big fight about whether or not it's ever yielded anything important that's led to some sort of conviction or enhanced investigation by the NSA. The government says it has here and there around the margins, and the people who criticize the program say, yeah, but you would have gotten it through other means anyway, so it really hasn't yielded anything. Bottom line on the Clayman thing is the government, of course, appealed it, right? Once Judge Leon granted that preliminary injunction, the government said, whoa, 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 you can't join our program. You can't stop our program from going forward. We're going to appeal. And Leon said, okay, I'm going to stay my preliminary injunction pending your appeal. So the bottom line with that case is pending before the D.C. Circuit, and depending on what the D.C. Circuit does, either that preliminary injunction will either go into effect or not. And of course, whatever the D.C. Circuit does, you can be darn sure there's going to be then a lot of pressure for the U.S. Supreme Court to jump in and resolve the ultimate constitutional question. And here's one reason why I'm absolutely sure the Supreme Court will have to do this, even though they probably don't want to, is because of that other case that came out of New York. A federal trial judge in New York, Judge Foley, reached the opposite result in the ACLU case. He dismissed the Fourth Amendment claim. What did he do? He relied extensively on Smith versus Maryland, said this is no different than what was going on with the pen register in Smith. He thought that the government had demonstrated some efficacy, some usefulness from Section 215, and that appeal is pending now before the Second Circuit Court of Appeals, which is basically the New York area. And so you're eventually going to get a Second Circuit decision, you're going to get a D.C. Circuit opinion, and if those cases still come out split, where one court goes one way and one court goes the other way, that's the perfect ripe environment for the U.S. Supreme Court to grant cert and hear the case and resolve the question. Another thing you might have heard about is the Rand Paul case. I'm just going to talk to you about it just for a minute because it's been all over the media. This was also filed in the same court where the Clayman case came out of, the federal trial court in D.C. Just a few weeks ago. This is a class action that was brought on behalf of Senator Paul and I think FreedomWorks, on behalf of all cell phone users in the United States, making the same Fourth Amendment claim as they did in Clayman. And it probably will get assigned to the same judge, Judge Leon, who ruled in the Clayman case. And then after Rand Paul filed his class action, Clayman, who won, at the trial court in D.C. before Judge Leon, said, hey, that's a great idea, class action status, we want that too. And so now they've requested class action certification from Judge Leon. That is likely to be ruled on within a month or so. They filed it in mid-March. That decision will be forthcoming pretty soon. What it's shaping up to be is this battle in the D.C. Courts of the class actions before Judge Leon, and we'll probably at some point get a consolidation. Because remember, even when Judge Leon granted that preliminary injunction in the Clayman case in favor of Mr. Clayman and the other plaintiffs, that's just a preliminary injunction. He still hasn't ruled on the merits of this case yet. He hasn't ruled on the merits of the Fourth Amendment. So probably the Rand Paul case and the Clayman case will get consolidated before Judge Leon. And a lot of people wonder, well, why did Senator Paul even bother to do this since Clayman had won? It's probably just because he is looking long term and perhaps thinking about making a 2016 run for president. And then we had a request by Clayman. Clayman was trying to get his case to move ahead of Paul's case and not get it consolidated with it, but the Supreme Court denied expedited review just a few days ago. So again, these two things are simply sitting there before Judge Leon. And I think that may be my last slide. Let me just see if I did anything. I did. Let me just wrap up and talk to you a minute about Congress and the role Congress is going to play. I've talked to you about the courts and how this is all playing out in the courts and we don't have an answer yet. But Congress has a huge role to play here. There's a lot of bills pending before Congress. There's one called the USA Freedom Act. That's the Sensenbrenner bill you may have read about. That one would get rid of 215 altogether, just completely get rid of it. The Feinstein bill, she's the chairwoman of the Senate Intelligence Committee. That is a more low-key bill, and basically it just sort of toys with or tries to reform Section 215 around the margins, but it wouldn't get rid of 215 altogether. So that's basically the choice eventually that Congress is going to have to make. If Congress decides to get rid of Section 215 altogether, all of this stuff is mooted. Okay, all of these court actions will just sort of go away, and you can be sure that the Supreme Court will never grant cert, because why interject yourself into a hotbed political issue when Congress has basically gotten rid of it all? So we'll see. If anything's going to happen in Congress, I think it's going to happen before the August recess. And I think a lot of pressure is building right now to move these bills forward. But we'll have an answer within 6 months as to whether Congress is going to do anything significant or not. And if they don't get rid of Section 215, these cases, I think, are still viable, and we're on the path to Supreme Court resolution. Okay, and so I'll stop there, and I think you probably have some questions for me. At least I hope you do. And let's talk about it. Yeah.
What is the relationship?
Oh, I have to move toward him? Okay. Yeah.
I really enjoyed your presentation.
Thank you.
What is the relationship between the NSA and, say, the telephone companies in regards to them having to give up their information?
Yeah, well, what they have to do with the telephone companies is they'll send them a letter, basically a national security letter, and they'll say, we want your stuff, right? Give us your stuff. And so far, the telephone companies have been pretty cooperative about that and have simply turned it over, because when they start making noises about, we don't want to turn this information over, then the federal government brings down the weight of the federal government and says, look, you can't mess with us. We've got FISC approval for this. And at that point, there's really no incentive for the telephone companies to fight them. They have around the margins, but for the most part lost. And what I will say is that one of the proposals, for example, that President Obama has put forward is that we change who's holding this information. If you receive a national security letter and it's a 215 request, you are not allowed to tell anybody that you've received the national security letter, so it's kind of like a gag order. That's one of the things that the phone companies have been mad about. So a couple of the bills moving through Congress would change that. The other thing that President Obama and Congress are fighting about is who's going to hold this information in the future if we reform 215. One of the proposals is to let the phone companies keep it. And then the federal government would have to go to the phone companies and ask the phone companies to run these computer metadata searches from the seed numbers. But you can see that the phone companies on some level don't like that. If you were a phone company, would you like that?
Absolutely not.
Yeah, because now you are beholden to the federal government to basically do their bidding and not only turn it over, because you're already keeping it anyway. So now when they ask for it, all you do is just turn over what you've got. But if the law is changed so that they have an obligation, then they're going to have an obligation to keep it for a certain period of time, to keep it secure during that time, and then when the government comes a-knocking, to run the searches for the government. So you can tell they're not real crazy about that. The other possibility was, well, let's not let the telephone company keep it. Let's not let the NSA keep it. Let's give it to some third party to keep it. And you can see that doesn't really solve the problem either, because who would the third party be? Would we trust the third party? The third party would have to spend a lot of money on security to make us all feel safe. They would have their rogue, Edward Snowden types themselves working for them. So I'm not sure that does anything but punt the ball. So if we're going to keep Section 215, we are going to have to resolve that very important question. Who's going to keep this stuff? And I don't know the answer to that. I mean, frankly, if you're going to keep 215, which I kind of wish you wouldn't, because I personally don't think it's been all that efficacious, I'd rather have the government hold it, frankly. But that's a second level of analysis. The first level of analysis is, are you going to keep it at all? Right? I hope the answer to that's a no. You're not allowed to ask questions. You're the clicker guy. I'm just kidding.
So the lower court cases are coming basically from Smith, right?
Yes.
Okay. And I'm assuming they're going to go to Leon because you believe the Rand Paul case is going to go to Leon because he's already
That's right.
he's already ruled partially on a case that's similar.
Yeah, just the way the D.C. Court's local rules work is that if there's already been a judge who has presided over a case that raises substantially the same issues, the clerk of the court generally assigns it to that judge again, just for efficiency purposes.
Okay. So, based on the Smith, Maryland, which was 5-3.
Right.
I know it's an awful thing to ask predictions because nobody, I mean.
But you're going to ask me.
I'm going to ask a prediction, but wouldn't it seem that the way the breakdown of the 5-3, I guess Stevens was the odd one out, but that was kind of before he went off the reservation. Isn't this kind of probably hinging on somebody like Kennedy?
It always hinges on Kennedy, doesn't it?
Not always, but in a case like this.
Yeah, I mean, most court watchers would assume, since he's the center of the court, that he's always the one. I do think
and
so.
He's a little bit more libertarian.
He is a little bit more libertarian. And I do think that even though the court composition obviously has changed substantially since 1979, that you can, generally divide the ideology of the court between conservative and liberal and kind of predict generally how they're going to come out. And then you look at the center and you see which way that guy goes.
Yeah, and well, I mean, the only way, because in Smith, when you've got Marshall and Brennan on the dissent,
Yeah.
you know which way that side's going.
Yeah,
So
I do think that's true.
I always like to look at that and I know it's changed, but,
But ideologies kind
Yeah.
of stay semi-constant on this.
Right.
I think that's right. And, it's interesting to me. I wrote a piece for the New York Post, I guess back in August, where I was talking about a New York federal trial judge who had ruled stop and frisk unconstitutional in New York. You may recall that. Got a lot of media attention. And I was shocked by that decision because here's a trial judge disregarding binding precedent of the Supreme Court that clearly said stop and frisk is perfectly constitutional. And usually when you're a federal trial judge like that, you don't do that. It's not your role. You don't consider that to be part of your judicial role to overrule the Supreme Court yourself. You basically follow the Supreme Court precedent until such time as the Supreme Court reverses itself, and then you follow whatever they said. So it was a pretty bold opinion by Judge Scheindlin. And one of the things I noted in this piece I wrote for the Post was that, even Thurgood Marshall supported stop and frisk in 1968. So the liberals on the court in 1968 thought stop and frisk was perfectly constitutional. Now, whether the liberals on the court today would think stop and frisk is constitutional if a case ultimately comes to the court, I think is an interesting question. So what that just tells you is that sometimes ideologies do shift and change their minds about things. So just because the left on the court did something a while ago doesn't necessarily mean the left is going to do it today.
And I'm sorry, I don't mean to take up all your time. Will Kagan be able to sit that case?
She should, yeah. I mean, it's always up to her as to
know,
whether or not to recuse herself, because she's got so many things that she was involved in her prior life that she could be recusing herself all the time. And most judges are pretty circumspect about that, unless it rises to a pretty high level where most people would look at it and say, you're going to be totally biased. They'll stay, yeah. Well, but we all are, right? I mean, one thing I try to give people a little bit of slack is that, judges are not computers. They're human beings. They come to the court presumably with their life experiences, and we pretty much know what we're getting when they sit before the Senate Judiciary Committee for confirmation, which is why those battles are so fierce. The problem is, of course, that those battles have become so fierce that to get people past the Senate, we've had to start nominating people whose records are very murky, very incomplete, very inchoate, because they haven't published a lot or they haven't talked a lot about things. And those are basically the only people now we can get past the Senate, which is kind of sad. Because I like having people in the court who've thought about these things for a long time and talked about them and written about them. And even if they disagree with me, as long as they've talked about it and written about it in a thoughtful way, in an informed way, that doesn't disqualify them in my perspective. But there's a lot at stake at the Supreme Court, so I understand why people's instincts are, he disagrees with me, let's not confirm him or her. It's just not the way I think the railroad should be run. Marshall.
Cell phones aside, what about the government intrusion into an individual's behavior on what website he visits, emails.
Yeah.
Isn't it a lot more sinister than tracking phone calls and first and second hops, that you sort of have this oversight of the government that really has could shape a profile of an individual's political likes, dislikes, emails and contacts. So does Section 215 authorize the government to engage in that type of intrusive monitoring of individual behavior?
Yeah, technically, I mean, you saw the statutory language. It's any tangible record. So, and remember that originally under Section 215, the NSA was in fact using 215 until 2011 to monitor email traffic. They stopped that in 2011, and they're not doing it any longer, but that was their voluntary relinquishment of that authority because they themselves thought it wasn't yielding anything. So they stopped. But in theory, Section 215 allows it because it doesn't just talk about phone records. It talks about any record. It talks about your library records. It talks about your health records. It talks about your internet records. Not the content, again. I mean, I do want to be clear, but think about, even if it's not content, if it's the analog to what they're getting with cell phones right now. Because what they're getting with cell phones is, you know, your phone number, all the phone numbers you're dialing out, all the phone numbers that are coming in. And first of all, make sure no analyst is actually seeing these numbers. This is a computer that's seeing these numbers. So nobody's actually laying eyes on it. But they could lay eyes on it. Just for an efficiency reason, they have chosen not to lay eyes on it until they start seeing patterns of calls between the suspected terror list that makes them then go to a judge and get a warrant to tap your cell phone and listen to the content of your communications. That's what they're doing Section 215 for. So, but all they're getting is just incoming and outgoing phone numbers. But if they wanted to, they could print it out, put some analysts' eyes on it, and they could start, you know, reverse white paging it, or whatever you do online, where you put the phone number in and it tells you, backtracks and tells you who it is and where they're from and what number it may be. So they could figure out that you're calling your psychiatrist, that you're calling your lover, that you're calling your pet groomer, that you know, whatever. They could figure out a pretty nice profile of who you are pretty quickly. Now, my thought about the email is that it's the same kind of thing for sure. It's incoming and outgoing email addresses from your email account, but not the content of your emails themselves. But think about how most of us devise our email. Mine, epricefoley@whatever.com. You can just look at that and see that it's me. Whereas if I give you my phone number, 305 blah, 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 you don't know it's me. You have to do some work to figure out that it's me. But you can do the work and figure out it's me, but you can't immediately tell it's me. With email addresses, it's kind of patent in many instances exactly who that is. And certainly if you're emailing back and forth with, you know, NARAL or National Organization for Women or John Boehner at house.gov or, you know, whatever, they can immediately see the list of email addresses and probably instantaneously know more about that printout than they could just the phone number printout. So it's scarier to me to think that they might do it with emails. But they're not doing that anymore. But could they? Yes.
But even are they? I mean,
and we just don't know about it?
I think their technology is so far advanced that if they concede on this point, that's because they don't need it. They develop technology where it becomes obsolete. I've been to, the technology is just mind-blowing. The nanotechnology, what they could do through monitoring purposes is just the data mining capabilities of the government.
Yeah.
Just from the last 10 years has advanced almost light years. And so
I agree.
So, you know, in your presentation on the Fourth Amendment is somewhat discouraging because the Fourth Amendment just seems to be a parchment barrier that there really is no protection.
Right, especially because of third-party doctrine.
Right.
They're going to have to, the Supreme Court is going to have to rethink the third-party doctrine if we want to have any constitutional protection for this kind of information that we turn over to ISPs or to cell phone companies and the like. So we either have that possibility where the Supreme Court changes its mind about the third-party doctrine, reverses itself in an overt case law, and develops some new standard for assessing the constitutionality of that, even though it's in the hands of a third party, or we have to get Congress to change the statute. There's only two ways to do it, right? Right now, it's looking more likely that we'll convince Congress to change the statute than we'll convince the Supreme Court to reverse itself. But we could do it either way. And I think what is driving a lot of this is exactly that idea that you articulated in the beginning, which is, you know, they say they're not doing this, that, and the other thing, but boy, we know they have the capability of doing it, and we really just don't trust them. And I'm with you on that. You can get me to go with you almost any time when you're talking about distrust of government. But I guess the problem is that sometimes just a blanket distrust without proof of the distrust makes it very hard to move the ball politically. If we had some evidence, for example, that the NSA actually was abusing the statutory authority, that it was doing things that it didn't have statutory authority to do, then I think we'd all just be going crazy, right, left, and in between. And Congress would have passed something by now. But the problem is we don't, even from Edward Snowden, we don't have that. The interesting thing to me is that Edward Snowden, everybody says, well, Edward Snowden is the one that got this ball rolling. Not really, because what was his name? William Binney, back in, 2001, 2002, right after 9/11, was blowing the whistle on the NSA. He and a couple of his buddies at the NSA went to the Senate, went public with all of this stuff. They were trying, in fact, to get a different software program implemented by the NSA that would have been more protective of privacy when using the Patriot Act and FISA Act. And the NSA turned them down, and that got them really mad, and they blew the whistle. And the American people knew it. It hit the New York Times. It hit, all the major papers. And we were just like, as an American people at the time. We're just like, whatever. I mean, it didn't go anywhere. But then suddenly Edward Snowden does it. And I don't know, maybe it's because he's kind of cute or because he went to Russia and they were trailing him, and it was like a good espionage almost type of story. It just made better news somehow. If you ever seen Benny interviewed, he's kind of a dull dude, kind of a nerdy guy. Maybe he's not the best poster child for the movement or something. And then all of a sudden, we got interested. But even under Edward Snowden, there's no yet any leak that the NSA is doing something it doesn't have the statutory authority to do. The closest they've come, you may recall, is the Love Int thing. Did you hear about the Love Int? They call it Love Int because I think it was 1 or 2 NSA guys were caught using NSA databases to spy on their girlfriends and spouses that they thought were cheating on them. And one of their colleagues ratted on them and said, they're doing this and they're not supposed to be doing this. And then, of course, they got fired. But that's an isolated thing, and that's 2 sort of rogue people doing what they didn't have the statutory authority to do, and they got punished very quickly and they lost their jobs. But in terms of sort of, some tip from Edward Snowden or somebody else that the NSA is doing those things that you're afraid that they're doing, we don't actually have any hard evidence that they're doing it. So right now it's just this sort of amorphous, we wonder if they're doing it,
So my question then would be the information that Snowden is slowly leaking. Is our government concerned about any of the information that he could potentially leak?
Gosh, I hope so.
And does that put the United States at risk for anything, whatever he leaks?
Yeah, I assume so. I mean, the problem is we don't really exactly know what he's got in his possession, right? So it's kind of, you have to just wait and see what he throws on the table and then react to it ex post. Like one of the latest things from him was this tip-off that we were, tapping into the cell phone communications of like Angela Merkel, and our friendly allies overseas, and everybody acted all mad about that. Oh, how dare you listening to my cell phone calls? And, my first thought was, of course we're listening. And, we've been doing that since the dawn of time. And I know we're friends and everything, but still we do spy on people. And I suspect you're trying really hard, if you haven't already, to tap into President Obama's cell phone. And, That's just the way that international espionage game is played. And the problem is, you say, well, couldn't we come together as, peace-loving people and sign an international treaty that we wouldn't, do that? I mean, President Obama has said that he thinks, as part of his proposed legislative reforms, he thinks we ought to put in the statute that some privacy protections for our friendly allies, so that we only do that kind of thing under certain statutorily defined circumstances. And my response to that is, do you really want to handcuff yourself that way? Is that really the wise thing to do? And if we pass this international treaty, let's say we did a giant international group hug about it, and we all agreed and signed some treaty, then you can be darn sure it's only the good guys that are going to be signing that treaty. All the rogue nations of the world would say, your treaty, we don't care about your treaty. Right? And those are the ones you're worried about the most. So, when it comes to that Section 702 foreign spying stuff, I guess my reaction is, it is what it is. It's embarrassing when that information comes out. We pay for it, a small foreign policy price for it for a while, but then it just all kind of shakes out because everybody understands that this is going on. But that's a small thing. I mean, who knows what Edward Snowden has? If he's got, I would assume if he's doing this strategically and being well advised, that if he's got the big nuclear bomb kind of revelation, he's going to hold that for a while. Yeah.
I've forgotten his name now. He just retired as the head of the NSA, General.
Oh, Clapper.
No.
Oh, he was
James
DNI.
Clapper.
Yeah.
Who was in charge of the NSA is just
Retired.
finished,
Okay.
retired.
Oh, the career Army dude. Yeah.
The second day before he retired, he got a sit-down interview with Brett Baer on Fox.
Oh, I didn't
And
see
they
that.
asked him that exact question.
What do you think he's got?
He said he is incredibly concerned about what he's got, was his answer.
And he didn't intimate like what kind
No,
of
well,
stuff?
no, he wasn't gonna, but Brett asked him like, the amount of information he's got, how concerned about the sensitivity of it is, and he answered it directly. He said, "I'm incredibly concerned about it."
Yeah, I don't blame him.
So I think they think he's got a whole bunch.
Right.
Whatever he's got, he'd probably be sure.
Well, and look
that
where he is
Russia
too.
has it.
Right, he's in Russia. That
China probably has it too. So.
right through Hong Kong. So it's his route has been interesting. I would be worried if I were Edward Snowden. He's useful right now.
Exactly.
But so he has an incentive too to trickle this out for a long time.
He disappeared pretty quickly.
Yeah. I mean, so this is, it's a very dangerous game that he's playing, and there's been a lot of talk. I think it was the New York Times that had an editorial suggesting he ought to be granted some sort of clemency type thing, or some sort of pardon. And I definitely don't think that's a good idea. I don't think you reward someone who is. There's no doubt that what he did was illegal. You're not supposed to be in a sensitive, classified position like that and take it and run. I don't think that's good for this country. I think there were ways he could have done it that would have been more subtle, like Benny did. Benny did it, and he let some stuff out, and he didn't have to flee the country.
There is an entire process, right, if you want to blow the whistle, right?
There's a whistleblower statute, but I'm not sure the whistleblower statute would be applicable to this particular situation. But even outside the ambit of that particular statute, you can blow the whistle and position yourself pragmatically and politically so that if, let's say the administration wanted to come after you full guns with criminal prosecution, that there would be a lot of political pressure not to do that. The way Snowden did it was so crass and so almost amateurish, that he didn't give himself a chance to play that card domestically. I think he could have effectively. I don't know if he just didn't have advice of counsel before he took it and ran, or what. But I think if he'd sat down with a really good lawyer, this is one instance where lawyers can actually do some good, believe it or not. He may have been able to stay and kind of slowly have a conversation with Congress and the administration about things that he thought needed to be reformed.
If Section 215 is ruled unconstitutional, how does that affect the legislation as a whole? Well,
it's interesting. I don't think the courts are geared up to move that fast. I mean, as you saw, the two big cases that are percolating, actually three if you count the Rand Paul case, which will get consolidated with claimant. Those cases are just at the trial level. It's going to take 2 to 3 years before we get to the point where the Supreme Court would be in a position to resolve the conflict. And I'm sure if Congress is going to do anything, they're going to do it before that time period is up. Now, if we have Congress doing nothing really on 215 and they're just doing the Feinstein approach of tinkering around the edges with 215, then we could have a court ruling before Congress does anything significant. So it's kind of a chicken and egg thing right now. It's still going to be years. If Congress does something, though, don't you think, I mean, looking at the pressure that is currently being put on Congress, don't you think they're going to do something before the August recess? Because if the longer they wait, kind of the more stale it gets. And the only thing I think that would revive it is if, Edward Snowden drops something and it's bigger. Well, and we just don't know if that's going to happen. Yeah.
Okay, 2 questions. How broad do they define terrorists? And how often or not often do you have to communicate with someone to be defined as a pattern?
Yeah, well, you don't have to be defined as a pattern. In terms of who is defined as a terrorist, the statute just talks about individuals who are engaged in terrorism or individuals who are foreign agents. And so that definition is left to the discretion of the national intelligence agencies, including the NSA. So there is no ironclad definition of who is a terrorist. Here's the good news, even though that sounds a little scary around the margins. Their terrorist seed list is only a few hundred people. So it's not like they're calling me a terrorist or you a terrorist. I mean, these are 300 people that they know are bad dudes. But the problem is if you go 3 hops out of a list of 300 or so people, that's still millions of people. And we don't have to have a pattern to be caught in that net. All we have to do is be 3 hops out of that list of 300 seeds.
Okay, and if they happen to find you doing something illegal that has nothing to do with that investigation, do they pursue it?
They can't find you doing anything illegal with metadata because it's just metadata. So they're not tapping into the content of your phone communications. So if you're talking to somebody about, drug deals or, robbing a store tomorrow, they're not going to hear about that. They don't hear anything that you say. It is simply, what they notice is that your phone number and this seed phone number are chatting. And if they're chatting enough that they think they have probable cause to go to a court and get a warrant to tap into the content of your phone, that's what they do. They go to a court and get an actual warrant to then listen to the content of your communications. But Section 215 metadata is none of that. It's just watching, not even watching with eyes, computer watching of numbers and looking for patterns. And when a pattern develops, they have some sort of funky algorithm, right? When a pattern develops that's sufficient enough, that gets triggered, and analyst sees that pattern and says, that phone number is calling that seed a lot. There's something going on there. Let's get a warrant and find out what's going on. See how it works?
Okay, I think unless somebody has one more question or comment, because we have the room until 7.
I'm taking up all our time.
Okay.
It's kind of moving away from, but I can see some similarities. What is your view on, with regards to privacy,
Right.
and this is moving away from the NSA stuff, but on the ideas of profiling, especially when it comes to airlines and stuff like that, and the TSA.
Right. Yeah.
And I just wanted to get, your opinion on something like that, because, just to me, take for instance the underwear bomber. When you have a young man on a no-fly list with no luggage, buying a one-way
ticket with cash, yeah,
with cash
right.
from Yemen. I mean,
Red
at
flag.
some point, it would seem to be, maybe let's check him out rather than investigating the 6-year-old girl in Mickey ears.
Yeah, rather than patting down grandma.
Yeah.
Yeah.
Although I know they're now trying to like sew bombs into children, which,
Yeah,
you know.
and
but-
more women because, yeah.
But, I mean, I'm just seeing some similarities between like privacy issues and
Yeah, it's interesting. I mean, all of this, anytime you think about privacy at all, it's always balancing, right? Liberty, privacy,
liberty and privacy.
and security.
One goes up, one goes-
and
yeah.
that's right. And
Where
how
you
do you
wanna
balance
balance
them? And everybody's going to strike that balance a little bit differently. For me personally, because I fly so much, I don't mind. I consider it to be no more intrusive than a Terry stop.
Yeah.
And it's funny, I was just going through the Phoenix airport last week, and I was chatting with the TSA officer while my stuff was on the conveyor belt. And the guy in front of her had asked her about, well, you're going to see my private parts, you know, and I go through, and she's like, no, sir, you know, we have a new machine. We're very proud of it, and this new machine doesn't show the detail that the old machine does. It just kind of just shows a generic sort of blob, and if anything's on you, it'll just show up as kind of a different color, but they don't see the, you know, everything that they used to see. And I was thinking to myself, well, that's nice, but I don't really care if they saw it anyway, because, you know, it's some dude who is working for the TSA who presumably his job is to keep me safe, and he's keeping me safe, and he's the only guy seeing it. It's not like, I mean, if they started putting it on the web,
Yeah.
you know, I'd be
Which
mad.
of course could happen.
Right, well, they could, you know, but so far that kind of thing hasn't happened, and it's so de minimis, and the risk is so high, I think, of terrorism, especially on airplanes these days, that personally I'm not deeply offended by that one. Yeah, I'm more offended by 215, frankly, than that. Seems more obscure.
Okay, I want to thank Professor Foley for that informative presentation. And the James Madison Institute, which is the funding source for this series of the American Cause. We have a complimentary copy. Everybody, at least university students, like revolution, right?
Yeah.
Well, here's your go-to book, The Free Market Revolution. So we have plenty of copies for anybody who wants to pick one up. And thank you again for coming tonight. Thank you very much.
Thank you,
Thanks.
appreciate it.